crying my eyes out as well. But it seems to make a difference. Lovely. Press your hand. Thank you. Court rise. Court rise.
Yes, Mr. Chairman.
My Lord, I've just been dealing with the FII Supreme Court decision. The Commissioners, as I've also made clear, accept, as they must, that the always speaking principle is a general principle of statutory interpretation, and the starting point, the assumption, is that it applies to all statutes. How it applies, however, will be different in different cases. And although the always speaking principle can apply to taxing statutes and even to VAT statutes, the primary principle of the interpretation of VAT legislation, domestic VAT legislation, is that it will have to accord with EU law. So always speaking as a domestic principle mustn't offend that overarching primary principle. We've been struggling since reading the Upper Tribunal decision as to whether or not we should be making a broader submission that always speaking has no application to zero-rated supplies, which is, I suppose, in a way, the easy answer. But what we have is a strict interpretation and a standstill constraint, and also no exemptions being changed, the scope of exemption.
You came up with your genetically modified tomato.
Yes,
example.
paragraph 50 is my paragraph as an example.
So, and you say that it would be a tomato.
Yes, it's still a tomato. It still has the characteristics that were there in the food example, paragraph 50. When you come to zero rating generally, that's the kind of care that would operate. So, first of all, was X zero rated in 1975, taking one of the earlier dates? Or if not, if we're looking at Y, did it share the characteristics of X as they were understood in 1975? So that's the genetic tomato example. With a newspaper, if you apply that test, the characteristics of newspaper in 1975 were a good printed item that carried news content. Yes, of course, it has other ingredients. A newspaper compared with different news is it's periodic, condition-based, all of these things. But the core in 1975 is that it was a good.
Is that it was what?
Sorry, a good.
A good, yes.
Sorry, I'm separating goods and services. So it's a printed good with news content, and to interpret that term against the test we've been trying to formulate is to extend a zero rate to supplies which would not have been zero rated as newspapers as it was understood in 1975. So it follows that either zero rating doesn't apply at all, which is a submission we don't need
Either
to
always speaking.
Sorry. Just having a break has killed my brain. So either the always speaking principle doesn't apply to zero rating at all, which is a submission we don't need to make, or if it does, great care must be taken to ensure that the effect of the application of the principle is not to extend or expand the categories or items and thereby broaden the scope of the exemption. Can I then turn to the strict interpretation principle? We get that essentially again from Europe. The latest iteration, if I give you the reference without taking you to it, in Europe, is from the AMG case, which we set out in our own skeleton at paragraph 24, and it's a 2019 decision. It's in the authorities bundle at page 279, and it's almost identical to the language we found in the Supreme Court, SAE Education. We can also find some guidance in other European cases. Could I give you one reference? Talaka Beach. This is the caravan and contents case. And if you could note the Advocate General at paragraph 16 and 17 and her footnote references, and also the court at paragraphs 22 and 23. This is in page 81 of the bundle. The Advocate General begins her opinion at page 83.
Sorry, can you just give me the Talaka references again?
Of course. The first page of the report is page 81, my lord.
Yes.
The Advocate General Court, begins her opinion at page 83. She deals with...
Which paragraphs of the Advocate General and which paragraphs of the judgment is what I was after?
I'm sorry. So it's 15 to 17 of the Advocate General,
Yes.
85 to 86.
85 to 86.
And for the court, it's paragraphs 22 and 23, which are at page 93.
Thank you very much.
And the fact that in that case, the additional items, the contents were specifically excluded domestically was important, but it doesn't undermine the general statements made by either the Advocate General or the court. So could I then make one submission on SAE education? We of course don't disagree with or have any submission to make on it. It's the other case that is featured in the Upper Tribunal's decision that we wanted to mention. So SAE Educators with Kitchen at page 594, and it is in the Upper Tribunal's decision and in the skeleton arguments. See it live. It's at the report begins at 582, Lord, and the principle is at page 594, paragraph 42. In accordance with well-established principles, the terms used in Article 131 to 133 to specify exemptions from VAT must be construed strictly, Nevertheless, they must also be construed in a manner which is consistent with the objectives which underpin them, and not in such a way as to deprive them of their intended effects. And that's now almost identically worded to what you see in A and G. The other case that has been appearing in the jurisprudence over the years, and I think is referred to by the Upper Tribunal, is the judgment in the expert witnesses case. And that's at page 415. And this is a decision of this court. The phrase that they were considering was very different from newspapers or books. It was of a civic nature. What was meant by civic? Is it tied to a city, or is it broader than that? Aims of a civic nature. Lord Justice Chadwick set out the submissions, and at paragraph 17 on page 423 at the foot of the page, does not follow that the court is required to give to the phrase aims of a civic nature the most restricted or most narrow meaning that it can be given to those words, with which, of course, we agree. A strict construction is not to be equated in this context with a restrictive construction. There we begin to have difficulties. The court must recognise that it is for the supplier, etc., etc. And if you read through, you get to the Oxford English Dictionary on civic, and then right at the end of 19, it's this sentence, which we say, with great respect to Lord Justice Chadwick, it goes too far. The task of the court is to give the exempting words the meaning which they can fairly and properly bear in the context in which they are used. Fairly and properly is, we say, slightly dangerous language insofar as it might be seen as diluting what is found in the European case law and now in SAE in the Supreme Court. And the reason this is important is it then takes me into the Royal College of Nursing case and how the Upper Tribunal dealt with the dissenting judgment of Lord Wilberforce. And you've seen it now more than once. Can I show you it in the bundle at page 301 for the beginning of the judgment, and Lord Wilberforce at page 323. And between between B and E, Lord Wilberforce deals generally with acts of Parliament and in proper interpretation. And if I could pick it up in the middle between C and D, I expect you're now all of you familiar with the wording. How liberally these principles are to be, I should start earlier. Leaving aside cases of omission by inadvertence, this not being such a case between B and C, when a new state of affairs or a fresh state of facts bearing on policy comes into existence, the courts have to consider whether they fall within the parliamentary intention. They may be held to do so, or if they fall within the same genus of facts as those to which the express policy has been formulated. They may also feel held to do so if there can be detected a clear purpose in the legislation which, these words, can only be fulfilled if the extension is made. How liberally these principles may be applied must depend upon the nature of the enactment, strictness or otherwise of the words in which they have been expressed. The courts should be less willing to extend express meanings if it is clear that the act in question was designed to be restrictive or circumscribed in its operation, rather than liberal or permissive. They will be much less willing to do so where the subject matter is different in kind or dimension from that for which the legislation was passed, back to my goods and services point. In any event, there is one course which the courts cannot take under the law of this country. They cannot fill gaps. They cannot, by asking the question, what would Parliament have done in this current case, not being one in contemplation, again our case, if the facts had been before it, attempt themselves to answer the provide the answer if the answer is not to be found in the terms of the Act. So that is, we say, clear language. And my learned friends say in their skeleton argument that this judgment from Lord Wilberforce was fully respected by the Upper Tribunal in their decision and in applying a strict interpretation. Could I show you paragraph 89 of the decision, if I may? And it's in the core bundle at page 107. Earlier in the judgment, the language, the whole passage from Lord Wilberforce is set out in paragraph 44 on page 97. Here the Upper Tribunal then grapples with what that means, and he says this: the question posed by Lord Wilberforce is whether the statutory provision was intended to be restrictive or circumscribed as opposed to liberal or permissive. Although zero rating of newspapers is an exception to the general rule as to standard rating and so attracts a strict interpretation, this is not the same thing as saying that the provision was intended to be restrictive or circumscribed, which we say it is the same thing. Then this, similarly, although the provision permits newspapers to be zero rated, we do not think it accurate to describe it as intended to be liberal or permissive. Instead, we regard the provision as falling between the two extremes identified by Lord Wilberforce. And we just don't, with great respect, see that there is space for that analysis. And it's that analysis that then slides into Lord Kitchen in SAE Education. And it's paragraph 90 where it continues, with great respect, to go wrong. Similarly, we do not think that Article 110 precludes the operation of the doctrine on the facts of this case. Although it is true that our conclusion has a result that, for example, the digital edition of the Times, which did exist in 1990, will be treated as zero rated, so that in that sense there is an addition to the list of products that were zero rated as at 1990, we do not consider this is an extension of the scope of item 2. Rather, it is a recognition through a permitted tool of construction that item 2 includes within its scope the digital versions of the Times. Well, we can see how that is, again with great respect, wrong, because that would have allowed, if applied in Europe, unless this is a completely non-European approach, that this is clearly and obviously an extension. We submit that the reasoning by the First Tier Tribunal, the paragraphs 193 to 206, core bundle pages 164 to 167 is to be preferred, and the Upper Tribunal's criticisms of this reasoning at paragraphs 45 and 46 of page 97 is misplaced. So bringing this all together, before I do that, could I just try and, in a few words, see where the difference between us lies, that's between my learned friend and I. It's the overall position of the Upper Tribunal and News UK's position, looking at their skeleton argument, remembering the reasoning that was attractive to the Upper Tribunal, appears to be as follows. There are two steps. The first step, as this is in the UK legislation, ignore the EU context, the first step, and apply the always speaking principle. First, the ordinary, updated meaning of the word newspaper, or presumably any word in Schedule 8. So that's the first step. Then you come to the second step, and only then do you turn to the EU context and the restrictions it imposes, by which time the response can be made, but that word is within the ordinary meaning, see our first step. We're just zero rating what was always zero rating. This division, or this sequence, is, with great respect to my learned friends, in effect to ignore the EU context when it's inconvenient, and it's to ignore the 1991 date at standstill and the need for a strict interpretation, and is impermissible for the reasons we've been attempting to articulate. The commissioners, and now the court, so the commissioners when they were asked back in 2015, and now the court, still have to ask and answer the EU-based questions. Does including electronic services in the 1972 zero rate of newspapers accord with standstill and strict interpretation, or does it extend the scope of a permitted exception? So the reason I'm mentioning that now is that the attempt by the Upper Tribunal in paragraph 89 to create a middle ground may have been part of the response to my learned friend's submissions. So could I bring this all together again?
Can I just, you said when we came back that you don't have to go so far as to say that the always speaking doctrine doesn't apply here. Are you then saying that you don't have to go so far as to say that because this is a standstill provision in EU terms, that doesn't preclude developments after that? So the genetically modified tomato, I think you agree, is not excluded by the always speaking principle. And do you say also it's not precluded by either this being a standstill provision or by the strict interpretation principle?
Yes, we would prefer to say it doesn't apply at all, because that's the easier response. But over the years, there have been examples, and you can see them in litigation, but also in that list of cases of examples at the back of the HMRC guidance, where it may be necessary within the exemptions, within the zero rate, to look at a new example. If I could give you one from the case law, and then it's a case relied on by my learned friends called Harrier. It's only a first tier, I say only without disrespect to the judge, it's the first level case. But this is the case of a photo book. Is a photo book still a book? And the revenue...
Sorry, what is a photo book in this context? Do you mean a book of photographs, or do you mean
yes, when you go to, in the days when you would take your film to be developed, now then with a CD card or whatever, if you went to the developer, you would get your prints, or they could be provided in a book of photographs, of your own photographs. And it may be easy if I just show you the case rather than... It's page 464. This is said by my little friends to help their argument. We see it as not helping at all, but and I'm reluctant to spend too much time on the first year case, but if I could just show you what was going on. This is in 2011. And it's Harrier, as you'll see from the headnote, was a high-tech digital printing, photo processing and personalised gift managing company. And the dispute you will see in paragraph 2 of the judgment on page 466. The dispute concerns the correct treatment of the supplies Harrier makes in relation to what are termed photo books. Put briefly, Harrier says that its supplies are of goods, and that those goods are books or booklets, and as such, supplies of them are zero rated. So it doesn't deal with this change from goods to services. And it's instructive that the first question that Judge Berner and Mr. Templeman ask, based on that argument, is whether or not you have here a supply of goods. And you can see that in 3. And then at 2, alternatively, whether the supply of photo books constitutes a supply of services, in particular photographic services, in which case it would fall outside the zero rating. So the debate then takes place, and at paragraph 15 on page 468, you have the description that once the photo book or photo books have been printed, Harrier delivers the product either to the customer directly or to the retail store. So this company is also providing photographic services. And then when you get to the law on page 470, we have familiar territory. And eventually you get a conclusion, which is on page 473, paragraph 39. In light of our conclusion on the nature of the supplies made by Harrier, the real issue is whether the photo books supplied by it are books or booklets. Mr. Thomas, then appearing for the Revenue, referred us to Article 110 in Talaka Beach. He submitted that the provisions of the directive laying down exemptions to the general principle was to be interpreted strictly. And then there's reference to the judgment. And the finding is that these were goods, and you can see this repeated in paragraphs 42 to 44. And let me just give you 2 examples of why it's important for the commissioners that we don't throw...
What did they decide?
Page 316, paragraph 47. The words booklets and booklets to be given their ordinary meaning. The book refers to an object that has the necessary minimum characteristics of having a significant number of leaves, usually paper, held together by front and back, etc., etc. Then there's reference to case law. You might have a leather-bound book, and you get to 57 on page
478.
Yes, sorry, I've got old. Yeah, 478. It's paragraph 57. Test is an objective one, and we must be determined by reference to all the physical characteristics of the product in question, and the essential minimum characteristics of the object must have leaves, etc., etc. And they find that it's a book. And you can see that last couple of pages, paragraph 66. I'm sorry, my internal paging is gone. It's page 18 of the decision.
Yes, thank you.
The reason that I wanted to just caveat on your ladyship's question is that the revenue have lots of applications and requests to consider whether or not a new development is zero rated or not. And they have fine lines to draw. And as far as I understand it, I'm not instructed to prevent them from doing that by freezing with the precision that you would find with the civic nature argument, or indeed with books. So I hope that's a...
Right, so they don't apply the rules on the basis of, well, sorry, if it didn't exist in 1972, then it can't possibly be zero rated. That's not what they're doing.
It's not what they're doing. And you can see an example would be there might be a book that is now, because of technical developments, can be printed and produced in waterproof plastic. Off the top of my head example. But what you can't do is change the categorization, which is what we say is happening here.
So you don't challenge what the Upper Tribunal said about Article 110 and the strict construction precluding the operation of the always speaking doctrine in this case. But you say there was another stage that the Upper Tribunal missed out. It went from that to a conclusion that the word newspaper extended to digital services.
Yes, without
Considering newspaper.
but also because of what's said in paragraph 89, there is a reference to the strict test, but the Upper Tribunal seems to have been preferring a test that hasn't formally been articulated, a test that is somewhere between strict and permissive, which is very close to, and hence why I showed you Lord Justice Chadwick, the fair interpretation, and we say that's too lax. So could I bring this together in
But I mean, you also say the always speaking principle can't be used to turn goods into services, do you?
Yes.
I mean, it's quite simple. I mean, the always speaking principle in this case has to be applied against the background of the fact that you are determining an EU law question. What is vatable? And to do that, you have to presumably continue to apply EU law. And Article 110 doesn't abrogate an always speaking principle, as your tomato example shows, if I may say so, brilliantly. But it equally, the example demonstrates that that would be simply a different kind of good that still fell within the original definition.
I started some hours ago by showing you how the Commission has summarised the difference in their guidance. That's been their constant. We have a set of goods which have, since 1973, 1st of January, been excluded from the need to levy a tax. There will be developments, in not just this item, which is one of the easier items, but in food, for example, there will be changes. Children's clothing, what about the crash helmet for the child, etc. All of these different examples. But it still has to be what was there in 72, was there in 75, what was still there in...
And you say that European law was perfectly clear until 2018,
Yes.
that digital services were vatable.
And different in kind.
Different in kind and vatable.
Yes. Lord, in answering that, I probably don't need to bring these points together. The points I hope are fairly obvious now, where we disagree with the Upper Tribunal. And we've set it out in the skeleton argument. The FTT deals with the point and say it's fatal, that these are not goods. And we say, yes, they're right.
And I think you also say that it's simply not an answer to say that reduced VAT provisions are irrelevant insofar as they do show you what EU law is.
But what they are helpful, informative, and at the same time, you've got not only goods and services separating, you've got discussed in those cases the difference between the supplies made under the reduced services reference to books, the addition of physical means of support. That was an extension. Going on further is another extension. Almost as importantly, we in the UK and throughout the EU, there has been a grappling with electronic services. They've had separate identification, separate categorization, separate treatment, particularly in relation to place of supply. And that, without more, waves a red flag. This is different from goods. Lord, I've been responding to questions as well as making lengthy submissions. I haven't taken you to the case law. It's marked up in the bundle. It's referred to in the skeleton argument in the judgment. I would turn back, see if I've missed anything in particular. Two shaking heads, which is...
Well, you can always come back to other cases in reply if you need to
I
respond
haven't,
to
dealt
anything.
with fiscal neutrality, save to say that that is also a European principle, and you can't extend the scope with fiscal neutrality, and that should be an end of that particular argument.
Very good. Anything else? Thank you. Yes, Mr. Peacock.
Well, I propose to address what you've heard from my own friend under 8 broad headings, but before I do so, might I attempt to clear some of the fog or the artfully delivered smoke and give you some headlines as to where my argument is going to take me. First, it is often said that VAT is a harmonised tax across the whole of Europe. That is not completely true. Large parts of the VAT system are harmonised across all of the member states. The member states are left with some discretions where they must exercise their own choices. Zero rating in the UK has always been one of them.
One of what, sorry?
One of the circumstances in which member states make their own choices.
Zero rating, you submit, is a circumstance in which the member states make their own choices.
Or to be strictly accurate, the choice made by the member states is respected by European law, so that the VAT system is not fully harmonised, so that where member states in the UK deal with that which is zero rated, that is a matter of UK law and of UK statutory construction within a framework by which EU law sets boundaries on the exercise of the UK's discretion.
So I want to get that down precisely, Mr. Peacock, because it's not in your skeleton. It's a matter of English law. Say it again.
The question that this court has to determine in this appeal...
No, I want you to make the submission you make. That we're dealing with a matter of English law within a framework of European law, but I want the precise words.
Starting proposition is I accept that much of the VAT system across Europe is harmonised.
Yes.
That is not universally true, because there are aspects of the VAT system across Europe that are left to member states.
Yes. I mean, the key point in this case is whether we are dealing with a question of English law or European Union law, and that was why I wanted to hear so carefully your submission about it. And what you said, what I've noted down, because you didn't repeat it, is where member states deal with zero rating, that is a matter of English law to be decided within a framework of European Union law.
Yes.
Well,
Right.
what I got down is UK law and UK statutory construction within a framework by which EU law sets boundaries on the application of zero rating.
Yes.
And I missed the bit about the EU setting boundaries.
I think that was the framework. It continued from framework.
I mean, it would help me if you were to write down that submission for us in your own words, so that we have it. Because for my part alone, Mr. Peacock, speaking only for myself, this question, the Upper Tribunal treated this as far as I could see, as a matter of English law. They said that the things that the EU said and the prognostications of the Commission and the European Court were irrelevant. Now, I want to know whether you submit that as right.
Well, look, I am going to go on and explain why that is right.
Right. And it would help me overnight if you were to put your submissions as to which law we're applying in writing.
Well, we will do that.
Thank you.
But again, this is all by way of headline or sign.
No, I know, but unfortunately, once you dip your toe in the water, the sharks in this court, unfortunately, grab hold of it.
I fully
Speaking only for myself.
Yes, my lady and I are not sharks.
Well, that is perfectly understood, and I will not row back from a word I utter unless I indicate it.
Not once you've been dragged under by the shark, Mr. Peacock.
Unless I'm being dragged under.
I'm sorry.
I may need a bigger boat. But by way of signposting, I am going to draw this distinction between that which is a proper matter of European law, properly understood,
Yes.
and that which is a matter of UK law, properly understood. And even in that latter category, I am not denying there is an EU framework or context.
No, I see that. Of course,
I am
you
not,
couldn't.
as my lady friend suggested a moment ago, seeking to ignore that. We have to abide by it, and my construction, I say ultimately.
But what he says against you, which you will have to answer, is that you start in English law and only come to the EU law backdrop after you've already reached the conclusion you want. And he says that's the wrong approach, I think, because you should apply what the relevance is of English law, like the always speaking principle, which he accepts is potentially applicable, in the context of the EU law.
Well, I am quite content to do that. It does not matter to my case whether you start with the UK law meaning and then consider the EU framework, or whether you start with the EU framework and then come to the UK statutory meaning.
Right.
As a matter of structure or concept, it doesn't matter where you start.
No? Okay.
I fully accept I have to abide by both halves of that debate. The construction that found favour with the Upper Tribunal, fairly read as a whole, does abide by both halves. In our case, we would say certainly does abide by both halves. So I'm going to go on to say that the material you were shown, by which the reduced rate treatment of various items has developed over time in the EU, has no direct relevance.
And is that because you say reduced rate is an EU concept, whereas zero rating isn't?
Correct, my lady, yes. There is a conceptual and important distinction between a zero rate, exemption with a right of refund, which is permitted within a framework to the member states, and a reduced rate, which is a harmonised matter, which is a matter of European law. European Court acts as arbiter in relation to reduced rates, but it will only deal with member states that have zero rates, where those member states step outside the territory that is left to member states.
Well, couldn't you just tell me why, in that case, Article 110 deals with both reduced and zero rates?
Article 110 is doing two things within the same article. This is true of Article 28, its earlier guise. It is recognising that when states became member states, their earlier systems may have provided a special regime, being the exercise of some social policy choice by the member state concerned, where that special regime might have been a reduced rate. And in some circumstances, member states are permitted to retain that treatment.
Reduced rate, you
A
say.
reduced rate.
They can't shift that to being a zero rate.
No, because that would offend Article 110. So Article 110 has to deal with member states that had a reduced rate special regime. It also has to deal with states that had a zero rate special regime, which the UK was one. So Article 110 is saying to both of those member states, you have exercised a social policy choice in the past, you can maintain that as regards zero rating, providing you live with the framework of Article 110.
But I mean, it actually says the exemptions in the first paragraph must be in accordance with community law.
My lord, yes. That brings with it principles of EU law, so they serve to form part of the framework or the context. But the choice, the legislative choice, the social policy choice made by a member state, here the UK, in the form of purchase tax before 1972 and in the form of the Finance Act 1972, that choice is respected by EU law and will not be interfered with by EU law, provided that the UK does not step outside the categories of special treatment that it had hitherto provided.
But what does in accordance with EU law mean, then, in relation to zero rating?
Lady, there was a debate about that phrase, and in particular, did it bring with it, i.e. as part of the series of controls, did it bring with it principles of EU law? And the European Court decided in Marks and Spencer's that the answer to that question was yes.
It did bring with it EU law.
Principles.
Yeah.
But it brings with it principles of EU law, like the principle of fiscal neutrality,
Or strict construction?
or strict construction. But that does not bring the whole gamut of EU law, including the legislative regimes and the various changes. So what you have...
Sorry, I don't understand that. Where does it say it doesn't bring the whole gamut of community law?
We can turn it up and we can see in a short moment. It's addressed in Marks and Spencer's in the European Court. So what you are required to do as a member state...
In the VAT context?
Yes, this is only in the VAT context.
So I think you're saying that reduced rate means two different things, or it's referring to two different things. In Article 110, it's referring to a pre-existing reduced rate that was applied by the member state to whatever goods or services it applied it to.
Yes.
And that is then capable of being maintained in place. But the reduced rate provisions that we were being shown are something different. Those are not connected to what you used to do before a particular time. They are what is permitted to any member state to apply a reduced rate of VAT for.
They are provided by EU statute.
Yes.
So my lady is right. Now, I confess I don't know whether this member state is a good example or not, but let's just assume France had a VAT-like turnover tax before it became a member of the EU, the EC as it was. If that regime had a special treatment for a reduced rate, then France was permitted to maintain that, notwithstanding the introduction of VAT. And that's used in one sense.
Well, that's not what this is about, because this clause, this article, is about exemptions with deductibility of the VAT paid. So this is about VAT.
Lord, yes, I'm talking both about a reduced rate of VAT and the zero rate of VAT, which is an exemption with a right
Yes,
of
but if you're making, I mean, this whole article is about VAT, isn't it?
It is.
And if you're making the argument my lady put to you, which is that this is only about reduced rates and zero rates, rates that were applied before you joined the EU and not about anything else, so that there is a whole separate body of law which applies reduced rates once you have joined the EU, which is nothing to do with this at all, that's not an argument I've heard before. It's not in your skeleton.
Well, I had not anticipated until we heard from a learned friend this morning that we were going to have to address this, but clearly in light of observations made by the Court we are. But reduced rates, you will see reference in EU VAT legislation to reduced rates used in two senses. There is the sense where it refers to the historic treatment that a given member state is permitted to retain, and that is typically because that member state had that as a regime prior to a harmonised VAT system.
And that can be anything. It can be any kinds of goods or services.
Provided it meets the fifth indent of Article 17 of the second directive, which it has to be clearly defined social purposes and for the benefit of final consumers.
But it could be, I don't know, if when Austria joined they had special VAT for alpine horns or something, then they could maintain that.
That
But
is what Article
the reduced VAT rate regime may or may not include alpine horns for everybody, but that doesn't matter to Austria because they've had that in place all along.
The lady is right, but that was permitted of Austria. But then there is a harmonised VAT system across Europe that says, in principle, you must set that at a minimum rate. And for a long time, that minimum rate was 15%. But it was recognised at the level of EU legislation that there were some circumstances in which member states would find it politically difficult to insist on a minimum rate of 15%. So the directive allows you to have what are called reduced rates, or now even super reduced rates. The directive originally said you could have a reduced rate, but it had to be at least 5%. There was then a legislative change, I confess I can't remember the date, but it recognised that you might have a super reduced rate.
Well, let's not get worried about that, but the point is that the kinds of goods that you can apply the reduced rate are specified in the EU legislation and have to be interpreted in a harmonised way.
Yes, and of which my learned friend showed you the development in relation to books and books on physical means of support and then electronically supplied services. They are all a development of that debate about what should be the minimum rates on a harmonised level across Europe. And we are not concerned with any of that.
So you say it's just coincidence then that the definition of books and newspapers and periodicals and children's colouring books that's used for the harmonised version is the same as our zero-rated standstill provision?
Well, they reflect the same or very similar social policy choices, but analytically, as a matter of European law, they are different. Now, I quite accept they're driven by the same thing. So when we see the development in the treatment of electronic books, in this case it's not about e-books, but let's just pursue the thought, that reflects the piecemeal development of a still developing policy across Europe as to whether there should be reduced rates and at what level for e-books. And all of what you were shown by my learned friend is true and accurate, but it's not concerned with the exercise we're concerned with.
No, I mean, I understand your submission. Your submission is there are two very distinct categories of, in this case, zero rates, reduced rates the same. One, which is a category of zero rates according to the EU regime applicable to all members to harmonise the tax. And one is to the situation when you joined, where you get a once and for all exemption which is governed by Article 110 and is to be looked at according to the lights of what was there before you joined.
In that particular instance, I accept that I have to live within certain principles.
Yes, you have to live within European principles, but on the basis, you say, that you construe what was there before according to national law.
Yes. So the framework for my field that I want to invite the court to play on is bounded by the obligation to construe it strictly, which we know means not the most restrictive, it means strictly.
I mean, I'm a little concerned about that, your acceptance of that, because I don't see why you should accept it if this is a completely different regime, if everything that Mr. Fleming helpfully showed us this morning is irrelevant to the Article 110 exemption, then I suppose you get to the strict interpretation from the words the exemptions referred to in the first paragraph must be in accordance with community law.
I am told by the case law of the court
that applies generally EU law principles of equivalence and effectiveness and strict
here,
construction legality.
Because it is seen as an exception from the harmonised system, which it is.
Yes.
I must construe it strictly, where that is understood to be strictly and purposively.
Yes.
And we can have a debate about Lord Justice Chadwick's observation, Expert Witness Institute, as to whether he's saying anything different. That's maybe for another day. I accept that. I accept as a matter of English common law construction, it must be a purposive construction where we seek for the intention of Parliament primarily by looking at the words that are used. I urge upon the court that part of that exercise necessarily involves consideration of the always speaking principle. And I conclude from the exercise of living within those boundaries that ultimately the question for this court is, can the term used in 1972 by the parliamentary drafter fairly be read in light of always speaking and strictly and purposively as extending to a digital edition of the Times?
And you say it is quite irrelevant that under the current or pre-2018 EU law harmonised VAT regime, digital services were to bear VAT at the standard rate.
My lord, yes. So, in effect, this is a little simplistic, but in a sense, I'm either right or wrong as a matter of UK statutory construction.
Yes.
But the answer to that question is not determined by, or influenced by, or implied by the legislative developments in reduced rating for e-books in Europe.
No, I mean, it's the same point I put to you. I mean, it's not relevant, and that's why Luxembourg doesn't help them, you say.
Yes.
Because Luxembourg is about the harmonised VAT regime.
Yes.
And it doesn't matter for EU purposes that the UK item 3 means the same or different things in other member states because it's bespoke for the UK, unlike Annex 3, which has to be given the same meaning in every member state.
Exactly. Because it reflects a policy choice that the UK made in 1972.
Yes.
And Malone French tomato is not a bad example. But think of a biscuit.
Be generous, Mr. Peacock. It's a good example.
It's a very fair example.
Yeah.
So, food is zero rated. Confectionery is carved out. Biscuits are treated separately. Hence the great debate about Jaffa cakes, which I confess I can't remember the answer to. Are they a biscuit?
No one can ever remember whether it's a good or a biscuit. It's a sign of being tax
I think
specialist.
the answer is right. I think it is.
Cake, yes, that's right, yeah.
But that is an exercise, ultimately, in UK statutory construction within the framework of a field bounded by EU law principles.
And you say same here.
Same here. once you're inside that field, so I must stay away from the boundary, I accept that. Once I'm in that field, it is a matter of UK statutory construction. And I'm either right or wrong, and you'll tell us in due course.
Well, I mean, then we come to the always speaking principle, which is in itself quite an interesting debate, but it's a different debate from the one that Mr. Fleming mounts his appeal upon.
Yes, well, and just as a signpost, I am going to say in due course that the always speaking principle requires the identification of the original policy of Parliament. And I say here, brackets, the policy here was not limited by format. It was not to tax reading.
Then you face the goods versus services point as well.
I'm going to come to that in a second, but the second element of always speaking is it has to be the same genus. The only contention my learned friend now runs, indeed now can run, because he couldn't run ground 3, is to say that it makes all the difference in the world that one is seen as a matter of UK law and EU law as goods, and the other is seen as a matter of services. My lord, you made an observation from my learned friend this morning, I think, that suggested that one way of looking at this was to say goods and services were necessarily very different, whilst they might have some rules in common, some VAT rules in common. It wouldn't be a surprise if they had significant differences when we came to apply the VAT system. And as a matter of European law, the emphasis, I'm afraid, is the other way round. So we are told, as a matter of principle, that they must be treated the same, save where there is a particular EU law VAT rule that requires a difference of treatment.
Well, I mean, the fact that they must be treated the same, so far as they can be, because they are different things, different concepts, I understand. But the fact that they must be treated the same under EU law does not make them the same. And if it is right, and I'm not saying whether it is or not, but if it were right that the UK Parliament was legislating about goods, and what you are trying to fit into a good is a service, then you would be sunk.
Can I refine your Lordship's proposition that if you determine that Parliament decided in 1972 that only newspapers in physical form were to be zero rated, irrespective of later developments, if that was the policy, then I would be sunk.
Well, it may not have been the policy, might it? It may just have been the meaning of the legislation.
Ultimately, your Lordship is absolutely right. It's the meaning of the legislation to be discerned by looking at the words that Parliament has used, bearing in mind that it is now common ground that the policy to be achieved was to avoid a tax on reading, the dissemination of knowledge, the provision of information to the electorate to allow democratic accountability.
Yes.
Now, all of those aspects of that social policy, that policy goal, are not concerned with the format or the platform by which a newspaper is delivered.
Well, is that right? Because the policy goal is to encourage reading and dissemination of information by keeping the price lower than it would be if VAT were chargeable. But that, well...
And I would then say, and that the policy thus expressed is equally applicable to my subscribing to the print edition of the Times as it is to my subscribing to...
You don't subscribe to the print edition of the Times.
My lord,
You buy the print
my
edition.
lord, you do.
Times.
You do.
You can subscribe, but that's a different meaning of the word subscription. You subscribe in the sense that you can have a subscription. They sell it to you they sell you a year's worth of Times newspapers, which is different from being licensed by taking a subscription to look at material online. That the essence of the contract is quite different.
My lord, this may not be an answer to your...
Not that may not be that point may not be an answer to the point you're making, but it is important not to use the word subscribe to mean two different things.
My lord, it may also be the lord's observation is not factually correct. Because I, as a subscriber, let me go back a step. I, as a member of the public, can subscribe to the Times to have a print edition delivered through my letterbox every day. I sign a contract to that effect.
You sign a contract to buy the Times, and it is another part of the contract that they will deliver it to you every day.
Well,
That's not a contract. The delivery is not usually from the publisher, isn't it?
No,
They
I
contract with the news.
well,
Well, it can be.
Can
yeah.
be.
and here is.
So you can, for example, I subscribe to magazines where they deliver them through the post from the publisher every month. They come through, whatever the magazine is, in an envelope, a horrible plastic envelope, and there is no bookseller in between.
Correct. Nor are you paying £10 and £1 for delivery. You're just paying £10.
You're paying £10 for the subscription for 12 issues.
I can subscribe to the Times on that basis, indeed.
You can, yes.
Yes,
But
fine.
it's unusual.
No.
Well, what we do
it-
in my household, if I may, is that we get a series of little vouchers through the post, and you tear off a voucher and go and get the physical newspaper from a newsagent who will accept the voucher.
Well, that can be done. But if you'll allow me to explain the Peacock household.
Of course.
You have a subscription to the Times.
I would hope so.
No, not free.
Not free.
It comes in paper form,
Mm-hmm.
but the subscription we have allows us a delivery of the paper form and of the digital form.
Right.
On for the Rolls-Royce version.
Yes, of course, Mr. Peacock.
So-
We assumed that.
And so that allows someone to read the paper at home,
Indeed. And
and I read it, let's assume, on the train. We are reading the same article with the same words and the same pictures and the same layout. It is the Times.
no, I understand all that, and I'm interested actually to hear the different subscriptions that people have, because I didn't actually know about my lady's version, and I didn't know about your version. But can I just put this to you? It doesn't actually stop the normal position, which is that the normal position is that if you read the Times, you will go into a newsagent and buy a physical copy of the Times, take it home and read it. And if you subscribe to the digital version, you will download it onto your iPad or your computer or your phone, and maybe all of the above, and read it, but you will never be entitled to keep that, to own that material.
Own that.
Material, the content. Whereas you do own a piece of paper with the content on it if you buy it from a newsagent.
My lord, that I have to accept is a difference.
Yes, distinction. You
Distinction.
say without a difference.
It is the product of the different nature. But we had just this debate before the first text. My learned friend made the point that you couldn't wrap chips in the tablet edition of the Times. You can't use it to light a fire. It's very different sitting at your breakfast table, downloading it, than it is to walk out in the rain to buy it in a newsagent's. All of that is true.
My wife doesn't think so. It still means that I read it and don't talk.
Well, we do use it to light the fire as well.
But all of this was addressed. There was a debate, part of the debate below, was there a difference of accessibility or readability or what else you could do with the paper that you couldn't do? And the first tier said, well, ultimately, none of that is a relevant distinction or a relevant difference.
Yes.
And just for your note, it's paragraph,
This is in the FTT.
it's in the FTT.
Mm-hmm.
Paragraph 157, I'll read for short. The fact that subscribers clearly valued the additional convenience afforded by the digital editions of the titles cannot disqualify those editions from sharing similar characteristics with the newsprint editions. As I have said, the evidence demonstrated that the reader's main priority was the content of the titles rather than the medium.
But the focus was on the content. There's a fundamental similarity between the content of the digital version and the print version.
Yes.
But the FTT found that the fact one was digital and a supply of a service, and the fact one was a good and the supply of a good was fatal to your case.
And the way the first tier reasoned was to say that when you looked at the terms of the group as originally enacted, that was only to be read as referring to goods. And once you had arrived at that conclusion, then any usage of the term to describe a service was necessarily an extension, and that breached either the requirement to construe strictly, or it breached the standstill, or both. And what the upper tier say is, when you look at the terms that Parliament has used in 1972, there is no inference to be drawn that Parliament determined only to refer to goods, irrespective of later developments. So you then have to ask, given that proposition, whether the always speaking principle can apply. The Upper Tribunal say yes, there's no EU law barrier to that, which Malone now accepts. So then it comes down to an application of the always speaking principle, and Lord Wilberforce in the nursing case. And the Upper Tribunal say once you've cleared the decks away, it does come down to a rather short point of UK statutory construction. And so I will go on in due course to say that once you've done that clearing of the decks and focused on the actual question, in circumstances where the social policy is the same, I say, the social policy is not limited or governed by format, and the always speaking principle can apply, then you're left with, does it apply here? The Upper Tribunal said yes. And the conclusion that a digital copy of the Times is fairly to be described as a newspaper should not be a surprising or unusual conclusion. Perfectly modern, common sense conclusion. I read the Times on a tablet, I'm reading a newspaper.
But why book is in group 3.
It is.
It's a 0 rate item. Why has that attracted so much EU controversy when it came to e-books? And you say newspapers are exempt from that controversy.
Not exempt from, but not part of. That's a fine distinction, my lady, but it is this, that there has been growing recognition across Europe that there was no relevant distinction between a book and an e-book. And the European Court has said that in Luxembourg and in RPO. There's a passage I want to show you in RPO about goods and services in a minute, but let me just pursue the thought. Given that, where the original EU level legislation dealt with reduced rates just for books, and then it was for books on physical means of support, Then there's some case law about whether it should extend to e-books, and the European courts say, well, in principle it should, but the problem here is the EU legislation. Then the only solution as seen from Europe is to amend the reduced rate legislation. And that has now happened.
You say that's the entire regime applicable to the harmonised tax, which has nothing to do with the exemption in Article 110.
Correct.
So the answer to my lady on your case is that that's all very interesting, but if books in part 3 means books and e-books, and under the always speaking principle always did, then that's the answer to that question.
So be it.
So be it.
Now, I need to make clear that we are not here fighting about e-books. It's no part of my case to advance an argument about e-books.
That's the next case.
That may well be another case.
But the
But then you end up with books meaning something very different when it appears in the EU legislation from what it means when it appears in item 3 and Schedule 8.
And even though the two clauses are virtually identical.
But that is a consequence of the social policy choice originally made by the UK in 1972 and the EU's arrival at that same point 50 years later, practically. But the fact that EU legislation only deals with reduced rates as regards e-books in 2018 doesn't tell us anything necessarily about the scope of what the UK Parliament did when exercising its own choice in 1972.
I mean, for my part, Mr. Peacock, obviously the argument is entirely intelligible and slightly different from what I thought we were dealing with before you got to your feet. But you will need to actually make good your point that Article 1110 is simply an exemption and is entirely separate from the regime of harmonised tax. Because whilst I accept it for the sake of argument in this discussion, I would want to be satisfied that there really was such an appropriate distinction.
I accept that, my Lord, and we will show you chapter and verse. There are authorities already in the bundle that will make that clear, but perhaps if I reflect on it overnight and produce something very short in writing that would draw those threads together, that might be helpful.
Yes.
But I've broken off just from tackling the proposition that there may be some radical difference between goods and services here that ought to drive the answer. Can I invite you to take up the authorities bundle? It's the RPO case, which begins at 233. And here, could you turn to paragraphs 49 and 50, which are page 241. This is all under the heading of treatment of comparable situations. And 49, the court concludes that digital books on physical means of support and the supply of digital books electronically amount to comparable situations. So in principle, they're comparable. And then could I just invite you to read paragraph 50?
Yes.
And that is a reflection of what the Advocate General had to say. So can I invite you to go back to 217?
Okay, can you just give me a moment? 217.
There's a heading towards the foot of 217, Fundamental Principles of the Field to which the rules relate. It should be paragraph 46 of the Advocate General's opinion.
Mm-hmm.
So that begins their comparability, so the different forms of books not precluded by goods and services, and then kind of invite you quickly to read paragraphs 47 through to 49.
Yeah.
So, in principle, we're required to treat them the same for that purposes. There may be instances where there is a difference of treatment, e.g. place of supply. But when one comes to look at the rate of tax, the amount that is to be charged, the general principle applies, namely that you should treat them alike. So I'm going to develop the proposition that goods or services isn't a relevant distinction.
Well, I mean, it may not be a relevant distinction under EU law. It may be a relevant distinction for deciding what the English statute meant.
Well, I am going to have to show the court and persuade the court that the conclusions arrived at by the Upper Tribunal, that there is nothing inherent in the language in 1972 that requires it to be limited only to goods, is right.
Yes.
And if I'm right about that, then I'm a long way home. If I'm wrong about that, then I'm not going to get home. So the significance of goods and services, you've had my headline on, reliance on and reference to the reduced rate legislation in the EU, you've had my headline answer to. The fact that there is a difference between downloading it at one's kitchen table and walking to a newsagent, true but not material, and the First Tier has found that to be not a material difference. Just by way of note, I'm sure you have this in mind, but we are here concerned with the e-reader edition, which is the one that you can click on that is a PDF. So what you see on the screen is an exact facsimile or photocopy of the pages of the Times. You flick from left to right or right to left as you turn the page.
Well, is that right? I mean, I don't imagine that many people actually read it in that way, but you can't subscribe just for the e-reader without the normal digital iPad edition, can you?
Not now, no. It was, in terms of order of development, the Times had a go at online first, website, it was 1996, not 1991, I was misremembering.
1996?
1996.
And that was online?
That was online.
Yeah.
The evidence before the First Tier was it wasn't terribly successful, it was rather difficult to do. So they then worked on developing the e-reader, which was in place in 2009. that is the exact facsimile of the Times. The tablet edition came along in May of 2010, spurred by the introduction of the iPad. The phone edition went live in June of 2010. And the website in its more modern format was up and running throughout our claim period, which here begins in
2010. And when was the subscription introduced? I mean, the money, because I seem to remember the website was free at one point.
It was.
Yeah.
First paywall, I think, was 1994, but certainly for all of, and I'll take instructions to check I remember that correctly, but for all of these different iterations, they were all subscription.
Right.
And at various points in time, you could take them in different combinations, or with or without the print. And at one point, just by way of observation that we don't rely on it, it was possible to subscribe for a digital edition on a daily basis. You could do it day by day, although that wasn't maintained for very long. It wasn't terribly economically successful.
And now it has to be per month, does it?
Yes, and I don't know whether it's 28 days or a calendar month, but think of it as monthly. But equally, I can be a Times print subscriber for 28 days or a month, or I can be a digital subscriber in one or more formats or variations, and I may be both a print and a digital subscriber. But when one comes to consider the meaning of the term used by Parliament in 1972, one needs to bear in mind that the Commissioner's case here is that the e-reader PDF version is not a newspaper. They don't say some of the digital editions qualify and some don't, they say all don't. Now that's a much longer introduction than I intended, but the 8 headings I was going to walk you through. Some will be quicker than others, but I give you the 8. And indeed we've covered a lot of the ground. 1, what is the right approach to this question of statutory construction?
Sorry, you have to speak up a bit. What is the right approach to what?
What is the right approach to this question of statutory construction? 2, what is the content and scope of the always speaking principle? 3, does the always speaking principle apply here in light of Group 3, Item 2? 4, if so, is the application barred by the obligation to interpret strictly and or by the standstill? Five, is the application of Group 3, Item 2 to supplies that are services an impermissible extension? 6, did the Upper Tribunal err in law? 7, does my learned friend's reliance on Article 98 and the analogy he seeks to draw with reduced rates have any relevance? And 8, the principle of fiscal neutrality. As regards the first of those, right approach to statutory construction in the present circumstances, I start from the proposition that we're here concerned with the interpretation of domestic UK statutory language. In circumstances where Parliament has provided for zero rating by what is now section 30 of the VAT Act, and that provides that a supply will be zero rated if it is the provision of goods or services of a description found in Schedule 8. It is an important point here that section 30 envisages that it might be goods, it might be services. There is no predisposition that it has to be one or the other. What you've got to ask yourself is whether it is of a description found in Schedule 8. If we walk through all of Schedule 8, some of the items of Schedule 8 are goods and some of them are services. But the fact that they are goods or services is not what matters. What matters is whether they are of a description found in Schedule 8 or not. Now we know that the UK is permitted to have and retain zero rating by Article 110. I'll come back to that. And we know that Group 3, Item 2 refers to newspapers, journals, periodicals. I'll develop this under one of the later headings, but it does not say print newspapers or news in printed form or newspapers in physical form.
It obviously didn't say digital newspapers because they didn't exist and hadn't been thought of at the time the legislation was drafted. Why should we not infer that it said printed music because there was such a thing as non-printed music, therefore it's drawing a distinction, but that it meant what was in existence at the time, actually meant the genus of what was in existence at the time?
Can I come back in a short moment and deal with music? But my learned friend suggested that printed was necessary to make clear that zero rating wouldn't encompass attendance at a concert.
Well, I was thinking more of a record or a CD or whatever they had, tapes they had in those days.
Well, if it were my learned friend's delineation,
that's not a...
It's obvious that you don't need to address that in that.
Yes, but music could be a tape in those days.
Yes. But if you think that the social policy or the policy good here that was to be advanced was broadly the advancement of education, now, we've had no evidence as to what the policy was behind the treatment of music.
Well, is listening to Mozart not education, perhaps?
It's most obviously education if you are given sheets of music that you then might try and either sing or play. But Parliament was perhaps concerned that it wouldn't extend zero rating to, show my age here, the Bay City Rollers, whoever was top of the charts in 1972.
I think they were a bit later than
My lady has a deeper understanding than I expected.
the Beatles. I think were still going in 19.
But the proposition was that you could see why you might want to make clear that it doesn't extend to a 7-inch single.
Yes, I mean, without getting into further dangerous ground, you haven't quite answered my question as to why, if it said printed music, because there is obviously music that is not printed, why it might have said printed newspapers. You can see why it didn't bother to say printed newspapers, because newspapers were then printed.
Well,
it was tautologies.
But my lord, the observation really was it ought to be the other way round. But Parliament can see in 1972 that there is sheet music, which for whatever reason it wants to zero rate.
Mm-hmm.
But it also knows that there is music in aural form, a record or a concert or whatever.
And it doesn't want to zero
And
it.
it doesn't want to zero that. So it's alive to there are two categories, X and Y, and we only intend to deal with X. So we insert the word printed. As regards newspapers, it's necessarily not alive to the fact that there are two categories, because X exists and Y doesn't. But one can't infer from that, from the absence of the reference to printed, or indeed the absence of any reference to physical form, that Parliament determined to limit the zero rating in the case of newspapers to that which was physical.
Well, even assuming you're right, and Parliament almost certainly didn't think whether it was limiting it to something that existed now or didn't exist, obviously, because it didn't exist. But can you say it's even of the same genus when something is created, which is, you see, it seems to me that it's quite different from the tomato. The tomato is a physical thing that is food for eating. Whilst you have successfully shown to the FTT that this is, to all intents and purposes, in terms of the consumer, the same delivery, the same thing is being provided, the actual way it is delivered is in an entirely different form, genetically different, one might say. It's not really the same genus.
In my submission, my lord, it is, because it's what's required. It has to be within the same genus. It doesn't have to be identical. It doesn't have to be genetically identical.
No. Well, I mean, we don't need to define genus because that's not very helpful.
But it doesn't answer the question because
No.
it's a conclusion, not a...
Anyway, it's a word from a different field, from a medical field used, it's not helpful. But it is a very different thing to have a digital newspaper. I mean, ultimately, the case may turn on this as to whether it is or not.
I would approach my answer to that by saying that the policy goal here is equally advanced by X or Y.
I think that's clear.
The policy goal could be advanced by the rolling news in the same way as the FTT said, but that isn't, you would agree, within the same genus.
No, because we successfully established before the first tier and in the upper tier that to be a newspaper you had to draw a distinction between edition-based curated news
Yes.
and rolling news. And there will be some newspaper organisations that still find themselves on the wrong side of that line.
But they still meet the policy goal, so it can't just be determined by the policy goal.
It has to be, you have to meet the policy goal. That's a necessary element, but not sufficient. And the second element is you have to be the same genus. Now, in circumstances where the first tier have found that there is no relevant difference to the reader, one is only left with a difference of tax classification of the format. Or if you want to push back on that, with a classification of the format, as between the print copy that will go through a letterbox and the digital copy that comes down out of the ether onto my tablet. But to the first tier, that ultimately wasn't a relevant distinction when one looked at the similarity between X and Y. What drove the first tier was their conclusion that Parliament had determined only to deal with print. And if they're wrong about that, then I would say with respect, you should conclude that they are the same genus, particularly in a world where we know as a matter of high principle that one shouldn't draw that distinction between goods and services unless it's required. indeed, my learned friend very fairly just thought the only reason he gives for a difference is goods versus services.
Well, yes, but in that difference is encapsulated all sorts of differences as to the way the thing is produced, costs that go into making it and distributing it, and the way that it's consumed.
I mean, that again, with respect, that's not quite right. The way it's produced, the first tier found, was identical.
Well, the way the content was produced, they found was identical, but there's a lot more to it than the content.
And then, once there's that common process, one can think of this as being actually two buttons. You hit one button to send it off to be printed in Hertfordshire, and it is delivered by a man in a van in newspaper form. Or you hit the other button and it went to a server and then it would download at 5 o'clock the following morning. So the method of delivery is different. The content is the same. And the consumer didn't see relevant differences.
Well, it did. I mean, the consumer either sees something that gets your hands all black under the breakfast table, or the consumer sees something on the iPad that is, as you say, downloaded at 5 a.m.
But the consumer of the Times newspaper didn't see that as a relevant distinction.
But that's because the focus was on content. The content is the same.
No.
But the two things, one is a supply of a service and the other is a supply of goods, are different according to the FTT.
Well, it is true to say that in that language, a supply of goods is not the same as a supply of services.
Yes.
But it wasn't just that the consumer saw the content the same. They didn't regard the difference in deliverability or delivery route as being a relevant distinction, because what they were interested in was reading quotes at the Times.
But there's a jump for that. In fact, the RPO quotes that you took, yes, they are comparable. They are comparable situations, and that may mean that they should be subject to the same VAT regime, and that's presumably why the amendment was made in 2018 that we've seen and now implemented here. But what you have to say goes a lot further than that. To say not only are they comparable, but they are in effect the same thing, such that it's not an extension of the original text now to read it as including digital.
My lady, again, I would respectfully say that puts it too high. Think of the debate in the Grant case about disclosure of a document, where the debate was, were you obliged under the RSC rule, whatever it was, Order 24, to disclose a tape? And the judge, Mr. Justice Walton, comes to the conclusion that, bearing in mind the policy of the rule, that there was a sufficient similarity between paper and tape to come to allow the conclusion, indeed he says to require the conclusion, that the disclosure rule extended to tape even though it said document. And they were necessarily different, but they were relevantly comparable. You have to be the same genus, you don't have to be identical.
Well, and also you need to look at the nature of the legislation and its context, and whether you're looking at a restrictive regime or a regime that is to be more liberally construed. And disclosure, one would have thought, would be very different too.
Well, my lady, I quite accept that one can see exactly why the judge arrived at the conclusion he did. Think of the Victor Chandler case we haven't looked at yet. It's mentioned in the FII judgment. That was where you had a bookmaker based outside the UK that was beaming ads into the UK through teletext. And the always speaking principle was used there to read the Betting, Gaming and Duties Act in such a way as to impose a criminal sanction, because it was said there was a relevant similarity between what Victor Chandler were doing and what was barred by the Act. Now, technologically, they were different. But it was sufficient, they were sufficiently comparable to form part of a genus, bearing in mind the purpose of that particular bit of the betting and gaming legislation.
No, I think we may find, Mr. Peacock, that if, for example, paragraph 89 of the Upper Tribunal was wrong, don't turn it up. It's the one where he says there's an intermediate position between liberal and permissive and restrictive or circumscribed. So let's assume that the Upper Tribunal is wrong about the law of the always speaking principle. This would clearly be effectively another appeal from the first tier's findings. And the way you're putting it at the moment, if I'm understanding it correctly, is that you say that on the basis of the first tier's tribunal's findings, you can still succeed.
Yes.
But I think we need to look at those findings, because I don't think you say that any of the findings can be challenged.
Well, my learned friend attempted to challenge some of the findings, and those contentions were rejected in the Upper Tribunal.
Yes.
And he wasn't given permission to appeal.
Yes.
So,
But I'm thinking about you now, because I'm assuming the UT's decision is, if the UT's decision is affected by an error of law, then we go back to the FTT.
well, ultimately in this court, strictly I have to persuade you that the Upper Tribunal didn't err, but ultimately what may well matter is whether the first tier erred.
Ultimately, it always matters. This is really just a second appeal from the FTT. I mean, I understand, because they've been overturned. Obviously, he has to show that the UT was wrong. But if he does, that's why I light on 89. If he were right in showing that the UT was wrong, then we will be looking much more closely at the FTT.
And just by way of headline, the first 160 paragraphs of the first tier's decision are about the facts.
Yes.
And the first tier comes to the conclusion that there are no relevant differences between the different iterations of the Times and the Sunday Times.
Between the content of the different iterations.
Not just the content.
Well, that's why I want to look at it. I mean, maybe we can't do it now, but I think we need to also be very careful as to what precisely the Court of Appeal does when it has this ping pong between tribunals.
Well, I have that well in mind.
Yes.
It may be a more efficient way to come back and show you the relevant bits of the first tier tomorrow.
Yes, when you've thought about it, yes.
What about the genus?
No, that's why I raised it now, Mr. Peacock. Yeah.
But to take my Lady Justice Simler's observation, it's not just about content, and I will take you to the relevant passages. But again, I'm not making a lot of progress with what is my first point.
But I mean, when you set your 8 points out, I knew what your answers very clearly were to each of them from your introduction. So, in a way, you have made a little progress in your submissions, Mr. Peacock.
What I'm ultimately going to invite you to conclude is that given the facts found by the first tier, and if I am right, and the Upper Tribunal are right, that they erred about the language used by Parliament in 1972, and if there is no principled barrier to the application of always speaking, then I should get home, because I would be giving effect to the agreed purpose of Parliament, and I would be within the same genus.
But maybe not if they're wrong in Article 8, in paragraph 89.
Well, what the Upper Tribunal say in 89 is to draw a distinction between liberal and permissive on one hand and restrictive or circumscribed on the other. Now, the Upper Tribunal say, well, we sit on a spectrum somewhere between those two.
Yeah.
And it may be your Lordship's point is, well, there isn't really a spectrum, you're either one or the other.
Well, not that you are fixed with European law principles, and it is strict.
I'm going to, and I have accepted, that one of the principles that bound the field I invite you to land on is the requirement to read the UK's zero rating provision strictly, but it has to be strictly and purposively. And it's not the most restricted. So one has, there's standing right back, there is a tension here between the EU's harmonised system and the original policy choices made by a state that became a member state. And the EU will permit that to continue, provided that certain principles are adhered to, one of which is that you should not extend.
Yes, but you are seeking to extend.
Well,
this is the whole point. I mean, it's very clever.
Not. He says he's not.
Well, I say I'm not, because what is clear is that you cannot extend the categories of zero rating. But this court and the tribunals below face this sort of debate week in, month out, where you have to decide, are you being invited to interpret a provision, or are you being invited to extend it?
Yes. Well, I mean, I must give you notice of the fact that just reading the schedule, I would say, in common parlance, not as a lawyer, that it's plainly an extension to include digital editions of newspapers that are devised 40 years later. I understand the logical, rational argument that gets you to where you want to get, but I think construing a statute which is plainly about goods made in 1970, when nothing that is in that list could be provided digitally because digital didn't exist, is an extension. But I mean, of course, I understand the argument that says it's not. What I'm really troubled by is that I still think you're slightly doing what Mr. Fleming accused you of, which is asking us to just study the always speaking principle as if there was some great benefit in construing this statute liberally and permissively and giving it its full connotation had everybody known the future in 1970, and then asking, does European law change that? Whereas what you need to do is put your European hat on first, explain precisely what the European principles are by which you are bounded on your very, if I may say so, very vivid playing field, and then make the exercise with those bounded principles in mind. What you're doing at the moment is saying, and it's attractive, Mr. Peacock, I mean, I don't deny it, of course it's an attractive argument, but I think you've got to get there through European spectacles.
I have a headline principle answer to that, which is, in this instance where you're looking at zero rate, you don't start with European law first.
Well, you do, because Article 110 says you do. It says you have these exemptions, but you must be governed by community law.
The court has my observation that we're here concerned with a non-harmonised part.
Yeah, no, and even if you're right about that, and I've told you that you must address submissions to that,
yep.
I'm assuming your argument that you're correct about that. But even if you're correct about that, Article 110 is clear in its terms.
My second answer to your Lordship's observation is that my end result, nor my route or the reasoning by which I get there, would not alter if we started with European law and then worked backwards.
I know.
I'm quite content if the court would find it more helpful to do it that way round. It doesn't matter to my argument whether I start at A and work to Z or the other way around.
But the reason I think you have to, and I'm only speaking for myself here, is because you are governed hand and foot by the provision that the exemptions must be in accordance with community law. And therefore,
Principles of community law.
no, it says with community law. And the community law that you say it's talking about are all the community EU law principles of effectiveness and equivalence and legality and strict construction and so on and so on. So you can only have an exemption if it's in accordance with community law. And you say that doesn't include the detailed provisions about the harmonised VAT rules for the reasons you've given, and you'll make that good. But if you make that good, you've still got to be governed by the principles of community law.
Just on that relationship between the UK zero rating and the harmonised system,
Yes.
there is a helpful judgment of the European Court, 1988, which was when the UK was taken to the European Court by the Commission for having misused its freedom to zero rate. And that is in the authorities bundle. It begins at page 60.
What's it called?
Commission against the UK. Ultimately, this case is about whether the UK has legislated zero rating in a way that doesn't accord. And the of the argument is best seen from the Advocate General Darman, page 65 of the bundle. And you will see from his bottom half of his paragraph 1, this is action against the UK for failure to fulfil its obligations. And then 6 lines down, the essence of the claim is the United Kingdom applies to a number of goods and services a zero rate which is not justified for clearly defined social reasons for the benefit of the final consumer as required by the last indent of Article 17 of the second directive. And can I invite you to read paragraphs 2...
Sorry, are you in the court's decision?
No, the Advocate
The
General,
Advocate General. Yes.
page 65 of the bundle.
Which paragraph?
I'd read from paragraph 1, which begins this action against the UK for failure.
Yes.
I was just about to invite the court to read paragraphs 2 to 5 of the Advocate General.
Well, that answers the question that we asked earlier about the stage at which it is zero rated. It's different according to the Advocate General.
One of the complaints, when we could look at the detail, was that the UK was not benefiting the final consumer. So it was accepted that the UK's zero rating was the same as exemption with refund. It was accepted that that was a permitted transitional arrangement whereby the UK's choices were to be respected. But what the Commission were challenging was the satisfaction of the fifth indent of Article 17 of the second directive.
That's the social policy.
Social policy and for the benefit of the consumer. And the detail doesn't matter, but my lady will see from page 69, we're still in the Advocate General, he's got a heading, clearly defined social reasons, and then the next heading is the final consumer, and then the next heading, the benefit of the final consumer, the concept of benefit. And then he does as the court does, which is to walk through the challenged items. And then the court's judgment begins at 74. And it's paragraphs 2 to 5. Court also recognising the transitional arrangements, the UK's freedom, the significance of the second directive.
Yes.
And then paragraph 10 of the court, page 76, records that there's no head-on challenge to the UK's zero rating system itself.
Mm-hmm.
And then paragraph 12 onwards deals with clearly defined social reasons, paragraph 15 for the benefit of the final consumer, and then the court walks through the various challenge items to see whether there's a breach or not. And those items we're not concerned with. Now, with that in mind, we then need to turn to Marks and Spencer's. I'm obliged. It begins at page 95. And this was part of the long-running dispute about chocolate-covered tea cakes. And one of the points in dispute was whether there was an EU law right to zero rating. Or if I put the point another way, was zero rating a matter of UK statute, or was it something that you had an EU law right to? In the head note, page 95 of the report, just above letter G, there is
What
identification
page in the bundle, sorry?
bundle page 95, just above letter G, is a list of the questions referred, Roman 1 of which, in the middle of the line, is whether Article 28.2, Article 110, both before and after amendment by that directive, gave a trader a directly enforceable community law right to tax, to be taxed at a zero rate. The answer was no, so page 96, first paragraph under held, I just invite you to read that quickly. turning on to the judgment of the court begins bundle page 115. And then over a couple of pages to page 118, they answer the first question. Page 119, paragraph 20 is headed the court's reply. Can I invite you quickly to read paragraphs 20 through to 24? The court is saying quite clearly in paragraph 24 that the zero rating is pursuant to national legislation, which is not a measure for the implementation of the Sixth Directive, in letters F and G. But the maintenance of that exemption or zero rating in the UK has to abide by the requirements of the second directive. So you don't have an EU law right to a zero rating. It's purely a domestic matter.
It's not purely a domestic matter.
Well, if one turns over the page 120 of the bundle, second question is, did Marks and Spencers have a right to a refund of VAT paid in error where they sought to rely on general principles of community law? So it was established they had no...
San Giorgio.
What they wanted to say is we have a San Giorgio right to recover the overpaid VAT in a world where the zero rating is domestic and not European.
They said no.
The European courts say, yes, you do have a right to recover.
You do.
So that's the heading, second question, page 120, just above paragraph 29. Observations submitted to the court, they are what they are. The court's reply at 32. I'm kind of going to read 32 through to 36.
Which stands to reason.
Well, no, I think it's a very odd result. That you don't. It's entirely up to the member state to decide whether to maintain in place the zero rating. If you as the taxpayer, trader, think that your product is within the scope of the exemption enacted by the member state pursuant to Article 110, and you have a tussle about it, but the revenue insists that it's standard rated. If you win, you say on the basis entirely of EU law, of domestic statutory construction principles, you then have an EU right to get the VAT back?
The way the court rationalises that is to say that zero rating is a domestic matter, so that alone doesn't engage EU law. But if it turns out that you have overpaid that, then the UK's adoption and maintenance of zero rating has to comply with principles of European law, one of which is that you have a right to be overpaid, to be repaid or overpaid tax.
Yeah. Which
so
is,
you have an EU right to your £35 million back, you would say?
Yes.
If we establish that, yes, ultimately yes.
Yeah. I mean, that's the situation, isn't
It is.
it's a San Corgio right, and it's overpaid tax, and it's overpaid tax of an EU tax, effectively. It's paid to the national government, but it's a tax imposed by the directive.
But this case and the earlier case reflect that tension between that which is EU and that which is domestic. The European Court are saying zero rating is a domestic choice which we will respect. You, Marks and Spencers, don't have an EU right to be zero rated, but if you can establish that you shouldn't have paid that tax, then you have a right to recover the overpaid tax.
But I don't see, I mean, I see all that, but I don't see how this affects the boundaries within which the second paragraph of Article 110 is to be construed. I mean, I understand it says you apply fiscal neutrality and it says lots of other things, but it doesn't tell you the entire boundaries. This judgment.
And your Lordship's observation is that, yes, it tells us to apply principles of EU law, but it doesn't tell us only to provide those principles.
Well, it doesn't tell you how you do so. So, you know, what I put to you earlier was that you must put on your EU hat before you start looking at the construction of the statute. And I think you said you don't mind doing that. So hopefully we're going to, but we need to know what the EU hat entails. And this is helpful in one sense, I agree. I mean, it's interesting, as my lady and I had a different immediate reaction to whether it was sensible, but I mean, I can see how they got to that conclusion. I don't see how it helps us here precisely.
It establishes that we are ultimately concerned with the matter of UK statute.
No, it probably helps you on the point that you made, that I accepted for the sake of argument, but said you had to make good, namely that the exemption is an exemption, an English exemption, and therefore has to be looked at as an English exemption subject to community law, in accordance with community law, whatever that means.
Yes.
And you know, this is a different situation from the usual situation that we encounter, where we're construing English legislation that entirely reflects EU law. And that this is a completely different situation. It's quite the reverse. We're construing English law, but with EU spectacles.
You're construing English law with some EU principles in mind.
Well, okay, I mean, we're actually doing it on the basis that it must be in accordance, the exemption that we are looking at must be in accordance with community law, whatever that means.
And can we note, to save me coming back to this later tomorrow, that one of the principles that is brought in is the principle of fiscal neutrality.
I've noted that, and I knew that you would want us to note it. Is that a good point to break? We've had quite a dense afternoon.
My lord, yes. And I will take away the things that I've promised to do and perhaps come back tomorrow and recast the order of my submission so we start.
I think that would be helpful, and I think it would also be helpful if you were to put in writing the crux submission that I may be doing you an injustice, but I didn't read in your skeleton argument. Maybe I read your skeleton argument with the wrong spectacles, but if you could bring it out in a few sentences, precisely what you say about how EU law applies and doesn't apply, that would be helpful to me.
Lord, we will do that, and if it involves adding any additional authorities to the bundle, we will do that by email.
Yes, that would be fine. And also, just if it's helpful, it would be helpful to me if you just put the authorities with the references in brackets when you state the propositions, just so we can follow them through. Good. Well, thank you very much. 10:30.
All rise.